Okay, I think we'll start now, if that's okay. Hello, everyone, and welcome to this afternoon's panel discussion on managing the arbitration process. My name's Ben Berry. I'm a partner at HFW's construction and arbitration teams. And I'm truly delighted today to be joined by a fantastic group of professionals in our panel to give their insights on this important topic. Just before I introduce our panel, I'll just go through a little bit of admin. First point is for those professional services colleagues amongst us, this event happily qualifies for 1.5 CPD points. Although unhappily for those of you amongst you who want those CPD points, you must stay for the whole thing. So none of this dropping out halfway through or running to the toilet and never returning. So I'm afraid you've got to stick with us the whole way through. We will try to finish on time though, so that's the silver lining on that cloud. Also, for those of you in the room, and I should say a big thank you to you, those of you coming, because we did have a cap on the number of people coming. So we appreciate you coming along. Thank you. And for those of you online, we also appreciate you logging on because there must be a lot of webinar fatigue amongst you all. So thank you for doing that. But those of you in the room, do feel free to go and help yourself to coffees and teas. Don't feel impolite by standing up and wandering over there. You're very welcome to do so. It's no problem at all. And also don't feel impolite about raising your hand if you have questions. We'll leave time at the end for questions, but also feel free to just chuck your hand up and ask us anything as you go along. That's no problem. For those Chinese colleagues amongst us, I mean, obviously the event is in English and it's simultaneously, for those of you online, it's being simultaneously translated into Chinese as well. But you guys, if you want to ask a question in Putonghua, that's no problem. Obviously, I won't be answering it, but we do have individuals here who will be able to immediately translate it for us. And we also have Yun, Karen, and Jianfei who can all speak fluent Putonghua, and they can answer your questions directly as well. So if that's needed. So over to our panel. Well, our panel includes my very good friend, Yun Xiao Hu, who sits here on my right, and she's Deputy General Counsel of Gammon Construction. Gammon is one of the largest Hong Kong construction companies. It's responsible for building some of the most prominent buildings in Hong Kong, including the M+ Museum in West Kowloon Cultural District, which some of you may know is due to be open this week, I think, isn't it? With the Ocean Park Water World, which opened last month, Tai Kwun and the Express Rail Station in Kowloon, to name a few. And they're currently working on an expansion of Terminal 2 of a building called the Hong Kong International Airport, which is an abandoned building up in Lantau that some of you may remember from 2019. Karen Chung is a partner in HFW's commercial litigation team. She recently joined HFW from Hong Kong law firm Lee & Partners, having previously worked at DLA Piper and Ince & Co. Karen advises state-owned and multinational clients on complex cross-border disputes, including general corporate and commercial litigation, white-collar crime, regulatory matters, shareholder disputes, SFC investigations, and judicial reviews. She also advises ultra-high net worth individuals and families in Hong Kong and China on a wide range of disputes. I would like to know what qualifies for ultra-high net worth, but I probably will never have to find out. A special thanks, by the way, to Karen for coming, because some of you who may have logged on a little while ago will have noticed that we had an Associate General Counsel from HSBC, Cyril Wynne Jones, who was going to be joining us, and unfortunately Cyril was not able to attend on this occasion, so Karen has come in her place. So many thanks, Karen, for doing that. We really appreciate it. Dr. Shala Ali is Professor and Associate Dean of the University of Hong Kong Faculty of Law. She's a Director of the LLM program in Arbitration and Dispute Resolution. Dr. Ali's work centers on cross-border dispute resolution in the Asia-Pacific region. She also sits as an arbitrator here in HKIAC and CTAC and SIAC. And good afternoon, Charlotte, who joins us from video link today. Jern Fei Ung QC also joins us from video link from London. Jern Fei is a barrister at 7 Bedford Row Chambers, specialising in commercial litigation and arbitration, and was recently joined as Temple Chambers here in Hong Kong as an arbitrator, and we're delighted to have him amongst our community. Jern Fei is described by the legal directories as an advocate who has the ability to present practical legal solutions that not only win you the battles, but also the war, which I thought was a fantastic quote. Just the approach we need for today. And last, but by no means least, we have my friend and fellow HFW partner, Peter Murphy. Peter is a dispute resolution specialist who will be known to many of you here. He has a particular focus on shipping, commodities, and commercial disputes. He's lived and worked in Hong Kong since 1997, and according to the legal directories, he's admired by clients for the quality of his work and his eye for detail. So a huge welcome to you all. Thank you. Well, what are we all doing here? Well, the title of our panel discussion today is Staying on Track for a Successful Arbitration. Enforcement in sight, all clear, or trouble ahead. So it's a broad topic, and we'll be looking at the life cycle of an arbitration from the decision made at the time a contract is drafted to include an arbitration clause, right the way through to enforcement of arbitral awards, and including, of course, enforcement of arbitral awards in mainland China. And as part of that discussion, we'll be covering the supplemental arrangement concerning the mutual enforcement of arbitral awards between the mainland and Hong Kong. Unfortunately, it seems that whenever they come up with these names, they don't have regard to the fact that it's a real mouthful to try and pronounce on these sorts of things. But so we'll call that the supplemental arrangement. And this was signed on the 27th of November last year, shortly after the last arbitration week, and amended the equally impossibly named Arrangement Concerning Mutual Enforcement of Arbitral Awards Between the Mainland and Hong Kong, which has been in place since 2000. And in summary, the supplemental arrangement further strengthens the prospects of parties in Hong Kong arbitration being able to enforce arbitral awards in the mainland. And this development, of course, follows the arrangement concerning mutual assistance in court-ordered interim measures in aid of arbitral proceedings by the courts of the mainland and Hong Kong, which came into force on the 1st of October 2019. And we're going to be discussing all these things in a little bit more detail today. But before we come to those issues and the issue of enforcement, of course, I want to start right at the beginning, really. And it's a point that actually us arbitration practitioners don't think about so much, which is the point, that vital decision at the start that kicks everything off to include an arbitration clause in a contract. And I'm going to turn to you, Karen, first to talk us through that decision from a business perspective, because when and how is a decision made by a business to include an arbitration clause in a contract? And what are the most important questions that the business, the people making that decision, will actually have when they're reaching that view?
Well, what I noticed is that as to your question is when and how the client would include an arbitration clause, and secondly is what are the important questions that the client would usually raise when including an arbitration clause. So what I observe is that when the clients include the arbitration clause, it's usually at the latest stage. It's a very late stage. They are very keen, the parties, to agree and enter and negotiate into all other terms, the nitty-gritty of the entire contract, except the arbitration clause, or how the matter will be resolved in case that there is a dispute. So we always say this is a midnight clause, because they realize at the end of the day, at the very last stage, they realize, oh, I need to include this clause in it. So the next question is, how are the arbitration clause usually included? So I observed there are two scenarios. So there are sometimes they're passive role, and there's sometimes it's active. I think the passive is very dangerous. So what happened is the parties will rush into or enter into a contract in a very friendly terms. Of course, everyone enter into a contract, hoping that everything will go smoothly. And then at the very last stage, they will say, oh, so what are you going to do in case that there's a dispute? So some clients will just download it from Dr. Google. That's the worst scenario. And the other one will just copy it like from the firms or for the companies boilerplate without knowing the details. And they just copy it without knowing. Or sometimes they think it's a standard terms and policy that they just adopt without knowing what it is. So this is the passive clients. And so when they come to me to say, oh, I'm going to arbitrate for this. And what is this about? What is ad hoc? What's the difference between ad hoc arbitration and the administered arbitration? So you start to give them a 101 lecture on what is arbitration for this kind of clients. And there's also another kind of client, of course, is the active role, taking a very active role in including arbitration clause in the contract. So what they do is that they will perhaps is you use the last agreement that has this arbitration clause. Or perhaps it's the company's policy, like most of the construction company or the shipping companies. So the vast majority of the contracts or the agreements will use arbitration clause. So they are more familiar with arbitration. Now, what are the most important or most frequent questions that the clients will ask is, so basically they will ask the applicable law to choose. Why do we choose Hong Kong law? And it's just here to promote a bit about Hong Kong law, because Hong Kong law is one of the few jurisdiction in the world that has bilingual. So for clients involving PRC and Chinese clients and also international clients. So all our law, both English and Chinese, and they can use at the same time. Even the arbitration ordinance is bilingual, so it's easy to understand and follow. And second, the next question is what will be the seats of the arbitration, and also what the institutional rules will apply. And most of the case, clients will come to me and say, what is the advantage of arbitration? So in the past, most of the people would say is because it's confidential, because it's not published online on the judiciary website. And second is fast and cheap. That may be debatable, but the most important thing, I think, is the enforceability of the award. Because Hong Kong and China, many other countries, we have 168 signatories to the New York Convention. So these signatories can enforce the arbitration award relatively much easier than a judgment. So this is actually is one of the main advantage of having arbitration over litigation. And most importantly, as a lawyer, you don't want your client to realize that after wasting all their money and time, precious time, they realize that they have an award that cannot be enforced. So enforceability, from my perspective, is the most important for all clients in a dispute. Thank you.
Thanks, Karen. So to go back to the decision, it's interesting you talk about active and passive decision makers. So there are some that sort of stumble into having an arbitration agreement because it's what they did last time or something like that. And there are some that actively choose it, and there may be many reasons for that. They may be the standard approach of the company or something like that. And Yun, is that your experience too, that the process that you go through to choose this arbitration clause is sometimes just a midnight decision made at the very last time, and everyone's too tired to really think it through?
I think in the construction industry is slightly different. It's not like in other commercial contract where people consciously make a decision. It's not like we in construction industry, we don't make a conscious decision, but it's just because most of construction contracts use standard terms, standard contracts, standard forms. So, and all includes a standard arbitration clause as a dispute resolution method. And that's why generally, like, we don't particularly say we choose something else. It's arbitration basically is the norm in construction contracts. So bearing that in mind, this discussion barely comes up in the Hong Kong construction contract, because we build in Hong Kong, we construct in Hong Kong, so automatically we don't really debate about the applicable law. We don't debate about the seats or the applicable rules for arbitration. But that doesn't mean that a discussion never comes up. So for instance, like when we are in a different jurisdiction, when we enter into contracts, like let's say Singapore or elsewhere, or maybe in some other jurisdictions where the courts are a little bit more like unpredictable, or the law is not as well developed, then in that case, we do need to consider that. And we do have a debate about that. Within Gammon, we have a preference for Hong Kong law, of course. But then at the same time, we also consider like Singapore law or Singapore arbitration seat in Singapore with the SIAC. That will happen when we, for instance, are entering into contract with Singapore or other jurisdictions that's a bit closer to Singapore. And at the same time, we engage a lot of consultants, for instance, who are global. So then, for instance, when the consultants are located in New York, in London, then this discussion will come up again. So then we generally will try to push back, and we say we want Hong Kong law and also Hong Kong arbitration. But from time to time, we will also settle for instance, UK law or Singapore law.
And Karen, you go back to you for a minute. You mentioned that enforcement, although you obviously stress, and quite rightly, how important enforcement is. You mentioned that, I suppose, there may be a disconnect between the importance that lawyers attach to it and the importance that commercial people attach to that question when they're drafting the contract. So, you know, what are some of the ways that you seek to mitigate, I suppose, the risk of you ending up, as you pointed out before, spending loads of money of your client's money and ending up being unable to enforce the award at a later date?
Well, enforcing an award, like enforcing a judgment, the most important thing is you see where the money lies. So where the counterparts and have the assets and also money. So in order to enforce, you look at where they put the money. So let's say in the place, so you will have to think like when the other parts, counterparts, the money is in the jurisdiction where the local court may be slow or unpredictable, or the other party has like some political influence over, you know, the courts or other authorities, then the decision of an arbitration clause itself is very important to mitigate the risk of enforcement. As I mentioned before, because there are 186 signatories that have entered into the New York Convention. So any arbitration rendered by a seat, rendered by a tribunal seated in a jurisdiction that has signed this New York Convention is capable of enforcement in any other of these 168 countries. So you can have a easier enforcement as opposed to litigation. Like let's say in Hong Kong, for example, if there's a judgment come to us, and if it's not part of the reciprocal enforcement ordinance in Hong Kong, then what we need to do is to go through like a start an action, like commencing an action and then sue as a judgment creditor. So it's a very long way to go, as opposed to just an arbitration, which you can just enforce it very quickly and swiftly. So some other ways to, sometimes I will advise the client to mitigate the risk include obtaining security from the opposing party. For example, like you ask them for a letter of credit or a performance bond, or maybe a guarantee from the third party with assets in Hong Kong or other jurisdiction with a reliable court system. So this is easily enforceable. And so I often have like clients or counterparts that is in mainland China. So when you have counterparts in the mainland China, I always advise the client to insist to choose Hong Kong seated administered institution as their arbitration. And because this will enable the client to recourse to various arrangement in place between Hong Kong and the mainland China. So because we have so much support of the Hong Kong arbitral award, enforcement of the arbitral award over the borders. So let's say, for example, Hong Kong, the court is very pro arbitration. So in 2020, according to the HKIC statistics, there are around 20% cases submitted to the HKIC that is administered under the HKIC administered rules. So this is the way to mitigate the enforcement.
Thanks, Karen. So, I mean, Charlotte, this might be a good point to turn to you to ask for your views on these various arrangements in place between Hong Kong and the mainland, which help to mitigate the risk of successfully or unsuccessfully enforcing Hong Kong arbitration awards over the border. Let's start with the 2019 interim measures arrangement, which many people will have heard of, even if they're not entirely familiar with what exactly it is. I mean, what is this, and how does it help mitigate the risks associated with enforcing the award at the conclusion of the arbitration?
Thank you so much, Ben. Yeah, no, this is a really unique arrangement which only exists in Hong Kong. So I'm happy to share a few words about it. This interim measures arrangement permits any party to an arbitral proceeding seated in Hong Kong and administered by either the HKIAC or another arbitral tribunal based in Hong Kong to apply to a competent mainland Chinese court for interim measures in relation to the arbitration proceeding prior to the issuance of the award, and even prior to the commencement of the arbitration itself. Just for those who might want a refresher, so the idea of the interim measures could refer to any type of compulsory measure ordered by a court or arbitral tribunal in relation to the subject matter of the arbitration. So this could be relating to the property of the parties, evidence, acts or omissions of the parties that are aimed at ensuring fulfillment of the arbitral proceeding and enforcement of the award. And then there's some examples that we can look at: freezing injunctions, for example, Mareva type asset preservation orders, or other prohibitory injunctions that preserve the status quo, such as an anti-suit injunction. And so before we had this arrangement, there were limited options that parties had recourse to. Generally parties would then, if they had assets in mainland, they'd have to either seek recourse to Hong Kong court or the arbitral tribunal itself, or an emergency arbitrator if the arbitration tribunal wasn't yet constituted. And then in the case of a foreign arbitration, courts in the mainland would only grant interim measures for foreign maritime arbitrations. And this was under a very special procedure called the Maritime Special Procedure Law. So now we have this new option which is available, which is very attractive, and I think has been used quite extensively. I know the HKIC has been collecting statistics, and they've been quite successful in having these interim measures enforced. And so the way it works, the process involves first the requirement that the arbitration be seated in Hong Kong and administered by a qualified institution. So it has to be under an institutional ambit, either HKIC, the ICC, or CTAC. And then in terms of what's required for the application, parties need to submit to the relevant institution an application, which is then forwarded to the relevant mainland intermediate people's court. And then the people's court is generally the relevant court is the one where the respondent's property lies or their place of residence. And there's a very minimal filing fee of about 5,000 renminbi, which is payable directly to the people's court.
Thanks. So that talks, obviously the interim arrangement, to bring it down to the basics, I suppose, that talks about steps that you can take before you have the award to help you improve the prospects of enforcing. So, for example, if you thought that the person you were going to have to enforce against wasn't going to pay and they were going to try and dissipate their assets before they had to an arbitral award against them, and then you'd find that you were enforcing against thin air. But there are, of course, some other key arrangements between Hong Kong and the mainland entered into in the last 2 years. The supplemental arrangement concerning the mutual enforcement of arbitral awards, obviously being the most obvious. How will this supplemental arrangement help mitigate the risk of successfully or unsuccessfully enforcing a Hong Kong arbitral awards over the border? And to answer this, I'm going to turn to you, Joan Fei, if you don't mind.
Not at all. Firstly, very good morning to you, Ben, and to the other panelists and obviously the attendees participating in person and online. This is a truly dynamic start to the Hong Kong Arbitration Week. This is in fact already my second HKAW event of the morning. So it's been a very busy start to the Hong Kong Arbitration Week, and I couldn't help then but respond to your quip at the outset of this morning's proceedings, where you referred to the Hong Kong International Arbitration, Hong Kong International Airport even. And I'm pleased to say that as possibly one of very few people in the room to have visited this apparently dilapidated, abandoned building twice in the past 1.5 months or so, I am pleased to report that the rumors of its demise are greatly exaggerated. It is in rude health, insofar that a building can be healthy, and perhaps it is getting busier and busier in time to come, and a barometer obviously of what I'm going to talk about next, which is about disputes, not just disputes involving parties between mainland China and Hong Kong, but also disputes involving parties from other jurisdictions which are seated in Hong Kong. And the reason why Hong Kong arbitration is very much in a very special position, at least insofar as they are involved disputes where there are parties from mainland China is concerned, is not just because of the interim measures arrangement which Shala had taken us through, but also the supplemental arrangement. Now, one might beg the question, what is it a supplement to? And in fact, this is why Hong Kong is unique in that regard, particularly with reference to disputes involving mainland Chinese parties. Following the handover of Hong Kong back to the People's Republic of China in 1997, there was a question as to the extent to which Hong Kong arbitration awards would be recognized and enforced in mainland China and vice versa, in circumstances where pre-1997 the position was governed by the 1958 New York Convention. In order to ensure that nothing falls between the cracks, the enforcement arrangement was entered into in 1999. Now, I refer to it as the enforcement arrangement, but in truth, giving its full name, its full whack is that it is called the Arrangement Concerning Mutual Enforcement of Arbitral Awards between the mainland and the Hong Kong Special Administrative Region, which is why short form abbreviations are a very good way, certainly for the purposes of webinars like this. It is an enforcement arrangement which provides special status for the recognition of arbitration awards which are published in Hong Kong, in mainland China, and vice versa. And what the supplemental arrangement does, which was promulgated very recently, entered into force in mainland China in November 2020, and most recently in Hong Kong by way of amendments to the arbitration ordinance, which took into effect in May 2021, is that it provides further clarification in respect of 4 issues in particular. So what the supplemental arrangement does, which promotes the enforceability of arbitration awards which are published in Hong Kong, in mainland China and vice versa, is firstly, a party can now simultaneously seek enforcement of an arbitral award in Hong Kong and on the mainland. Secondly, the scope of the enforcement arrangement, which preceded it in 1999, has been extended to cover not only the enforcement, but also the preceding recognition of arbitral awards. Thirdly, parties to arbitration proceedings with a seat in one of the two jurisdictions, namely Hong Kong or mainland China, may now also apply to the courts of the other jurisdiction for interim measures after the rendering of the arbitral award, and therefore where the interim measures arrangement previously focused on interim measures prior to or pending the arbitration proceedings, the gaps, insofar that there was a gap pertaining to post-award interim measures, was filled in by the supplemental arrangement. And fourthly and finally, the supplemental arrangement specifies that all arbitral awards, and not only those rendered in arbitrations administered by certain arbitration institutions, having a seat in Hong Kong may be enforced on the mainland and vice versa, thus shifting from the previously applied institution-based approach toward the internationally recognized seat-based approach. Interestingly, by way of footnote, the recognition of the concept of a seat, in other words, the juridical place of the arbitration, has also more latterly been proposed in the draft revised PRC arbitration law that is currently undergoing a consultation process. So those are the sort of four key highlights in respect of the supplemental arrangement and how it augments the enforcement arrangement which came into effect in 1999.
Thanks, Jianfei. That's great. And just to clarify for those people who that second point is actually really important. So we, at the moment under PRC law, and I'm not a PRC lawyer, of course, but just from my limited experience, the question is where the arbitral institution is based that determines, where the, if you like, the origin of the arbitral award comes from. And that, of course, is at odds with the general view in most other countries that are signatories to the New York Convention that say, well, where was the seat of the arbitration? And my understanding is it's a layover from the view that the PRC law will really only recognize arbitral institutions, institutional administered arbitrations. So rather than ad hoc arbitrations, such as what we have here in Hong Kong and England and Singapore and other common law jurisdictions. So that's sort of where we got to. And that change, I think, will be quite, it'll be subtle, but it'll be quite significant if and when it comes, that there may be a possibility of a greater recognition for arbitrations that happen on an ad hoc basis rather than just being administered by institutions. So we'll see how that goes. So, I mean, it all sounds rather positive so far, doesn't it? So set against this background, you say, okay, well, maybe to refresh our memory, maybe we have commercial parties that are entering their arbitration agreements at midnight, but as long as they get their idea around the fact that some enforcement is always a risk, if it's a counterparty in the mainland, hopefully they'll have got the idea that they need to be in Hong Kong. We've learned from Charlotte and Jianfei some of the advantages to that. So all things should be running smoothly. But Peter, are you able to throw some light on some of the more challenging situations where perhaps the process and procedure that we've learnt about, there are some bumps in the road, I suppose, should we call it, and that may not have been foreseen in that process?
Thanks, Ben, and yeah, happy to. But before I start, I'd like to echo the other sentiments. Great to be here again. Thanks very much for those attending in person. Thanks very much for those attending online. It's great to be part of this arbitration week in Hong Kong. So going back to your question, bumps in the road. Yes, it all sounded so rosy for the first, 30, 35 minutes. But let's divide this up into two broad sections. It's probably the easiest thing to do. First section, where a respondent challenges the tribunal's jurisdiction. So we've heard a lot about enforcement, but we're just going to move slightly sideways to challenging that tribunal's jurisdiction. And secondly, what steps can a claimant take, for example, to limit the risks at the enforcement stage? So taking the first broad category first, a respondent challenging or objecting to a tribunal's jurisdiction. Now, while these can be legitimate, so just to backtrack, arbitration has been commenced. Everyone thinks they're on track to proceeding to get their award. And a challenge has been brought or intimated against the tribunal's jurisdiction. Now, while these can be legitimate, certainly in my experience, slightly cynically, but certainly in my experience, the vast majority are, as I see them, are intended to cause delay and derail the due process of the arbitration. They can be particularly irritating. If you've got a claimant considers that it has a good case, it wants to crack on, it wants to push forward, it wants the timetable in place, it wants to have the evidence exchange, and the claimant wants to have the substantive dispute determined as cost effectively and quickly as possible. And then you have a massive fly in the ointment, which is a respondent who pops up and disputes the jurisdiction of the tribunal. Now, some examples that I see being made by respondents include one or more of the following, and they do link back to what we've been discussing earlier today. First, an argument that there's no valid arbitration agreement between the parties. Second, the tribunal has not been properly constituted. Third, perhaps the agreement or the arbitration agreement isn't wide enough to cover a particular aspect of the dispute. Fourth, the dispute has not been submitted to arbitration in accordance with the agreed arbitration procedure. Now, some of these issues, as you will appreciate, are different sides of the same coin. At one level, they do illustrate the importance of parties having one eye on a potential dispute, as I would say, being a lawyer, at the time of actually contracting. Now, Karen's comments were interesting about the decision sometimes being more passive than active. And I would say that parties just need to be careful that it's not too passive. Now, the examples, real-time examples that I've come across, the classic problem, is where the particular contract has conflicting provisions. And those of us in practice will almost certainly have seen this. For example, one provision in the contract provides for arbitration, and then later on in the same contract, there's another clause which refers to high court jurisdiction or similar. Now, the respondent jumps on that after the claimant has commenced the arbitration and says that the intention was not to have the dispute determined by arbitration. Now, a lot of you will know that intention of the parties will be viewed objectively, but as to that, it is fair to say that in recent years, insofar as a trend is concerned, there's probably been a trend towards favouring arbitration. So, of course, subject to the terms of a particular contract, looked at broadly, unless it's plainly the case that the parties intended high court jurisdiction over arbitration, tribunals will try to give effect to the agreement to arbitrate. And there is a helpful summary of this general principle, which was part of the judgment in the UK Supreme Court last year in the Enker against Chubb case, which I'm sure some of you are familiar with, where the court noted in summary that an interpretation resulting in an arbitration clause being void and of no legal effect at all gives rise to a powerful inference that such a meaning could not rationally have been intended by the parties. So there we go, a sort of a presumption in favor of arbitration. There's something else that can cause problems, is what we term multi-tiered dispute resolution clauses. And again, a lot of you in practice and in industry will be aware of these. For example, providing that the parties are obliged to negotiate before commencing arbitration. And a very short example of that type of clause is something along the lines that the party shall attempt in good faith to resolve any dispute by negotiation, which, absent any resolution within 30 days, shall be referred to arbitration. Now, frankly, whatever discussions or negotiations may have taken place, and almost certainly there would have been some before the trigger is pulled to commence the arbitration. If a respondent is going to dispute the tribunal's jurisdiction, in my experience, the respondent will almost always throw this into the pot of his or its jurisdictional objections as well. Why not, frankly? I came across an interesting quote when preparing for this from one commentator and well-known commentator who described these multi-tiered dispute resolution clauses as a dismal swamp of legal inconsistency, uncertainty, and disputes. So they have given rise to quite a lot of disputes in the last few years in Hong Kong, Singapore, and in the UK. But I think it's important to note that in Hong Kong, and I understand in Singapore, that a number of these disputes that have gone through to the courts, the general view is that these type of tiered clauses go to the admissibility of the claim rather than jurisdiction. But it's nevertheless important that when a dispute is brewing, the first port of call is to ensure that these types of clauses are complied with. Now we have one on the go at the moment. It's irritating, and we're needing to go back to the client to get records of all meetings, discussions, negotiations, timings, so that we can just neutralize it. It has no merit, but it's a time-consuming exercise. Then we've got other arguments that we see raised when a party is trying to challenge the tribunal's jurisdiction, and these perhaps are more linked to the merits than the others. For example, where a respondent argues that there was no contract, no arbitration agreement at all. Often happens when there's no formal signed contract, or perhaps where formal terms were drawn up, but no contract was actually signed, or where there are arguments about whether or not a particular agreement was properly novated. And this brings us to the process. So you're a claimant, you've commenced your arbitration, you're ready to proceed with your substantive claim. The respondent pops up and says that it wants to challenge the jurisdiction of the tribunal. Question is, what's the best strategy for the claimant to deploy to try and avoid or limit the delay that would otherwise arise from this? Now, frankly, in my view, strategy can be key, especially if one of the main purposes of commencing arbitration is to get the respondent to take the claimant's claim seriously. So this type of early skirmish, if handled properly, can put the claimant in quite a good position, and perhaps get the respondent to the table when the respondent was thinking that it could delay things by raising a challenge to the tribunal's jurisdiction. In other words, you can give a respondent a bloody nose in terms of strategy and procedure. Now, what do I mean by this? Certainly, in my experience, a respondent will invariably say that jurisdiction should be determined first before the substantive claim, for one or more of all of the other reasons I mentioned earlier. Now, a respondent will often dress this up as a cost-saving procedure. Well, if the tribunal finds that there is no jurisdiction, then it's going to save costs. But frankly, just a delaying tactic in most respects, so far as I see it. Now, for whatever reason, we've had a run of these in the last 12 months in arbitrations before the LCIA, the SIAC, and the HKIAC, where we've been acting for the claimant. And on each occasion, we've been able to push back. And it goes something like this, straight out of the traps. So as soon as you commence the arbitration, as soon as the initial deposits have been paid, as soon as the panel has been constituted, during the stage when the tribunal is or the parties are discussing directions, the respondent will come out and say, right, we challenge jurisdiction. They may say 1, 2, 3, 4, 5 grounds, or they say we object to it. There's a challenge, it should be determined. In most cases, the legitimate response to that at that stage is that the tribunal needs, and in fact must, be able to understand the issues before deciding whether to bifurcate, as it's called, i.e. have the jurisdiction challenge determined first before the merits, or whether the factual evidence is tied up with the jurisdictional objection and the substantive dispute, substantive dispute. So unless it's a very self-contained point, for example, a short point of construction of the contract, it should be the case that, and I think those of you in practice will have found that when a respondent is intending to challenge jurisdiction, it does it straight, it raises it straight away. But it should be the case of getting the pleading stage out of the way first, before the tribunal's able to decide to bifurcate. And I know this is a panel event, I don't usually quote from text, but if you are faced with this, paragraph 5.116 of Redfern and Hunter has a very good quote, and it usually does the job with the tribunal. And I will read it out to you because it just encapsulates what the issue is for a tribunal. And it says that if bifurcation is decided, any hearing on the merits is usually suspended and the jurisdictional issue is made subject to a pleading schedule, a hearing, and an interim award. Otherwise, the jurisdictional issue will be joined to the merits and the respondent will raise the objection in its defense. Now, this is the key part. The tribunal's decision will usually depend on whether the objection is a self-contained legal question that can be properly addressed without detailed knowledge of the underlying facts, in which case bifurcation may well be ordered, or a question that is linked to the merits and the facts of the case, in which case the tribunal is likely to consider it more efficient to address jurisdiction and merits together in a single hearing and award. So in a nutshell, when faced with an attempt to derail the process at the outset, it's for the tribunal to understand whether the objection is linked to the merits and the facts of the case. Hence, the pleading should run their course at least, and let's at least get the case moving forward. Now, turning to enforcement, I'm happy to talk about that now, but Ben, I expect you're going to ask me about enforcement trends. So why don't we park that for the moment?
I can't think for a minute why you suspect that, Peter, but there we are. It's also so ad hoc, this. You know. But I mean, I'm just going to pause there just for a minute, actually, and go off the script just for a point, just to see if anybody's got any questions in the room at the moment, just because I'm conscious that everybody has been listening patiently now for almost an hour. If not, we'll carry on for now. Yes, sir. Yes. Yes, yeah.
Are we saying that actually, even outside of arbitral instance, even at arbitration, we could take the front, the parties take the front, is interim measures.
But not at the moment, no. So the interim measures arrangement only applies if you have an arbitral institution administering your arbitration. But yeah.
In my example, have to pay the potential asset from owner. What if the substantial assets mainly own very little assets? These two parties you do major transactions in Hong Kong. It's still now with public pay. Everybody is at first the ideal that originally happened written with the arbitration code. Always is to see assuming that therefore if there is a claim the good notice of arbitration or either the interim relief act or ultimate therefore pay somehow I before the award is as
Correct. Yes. Yes. Yes.
In principle, yes.
In principle, yes. Thanks for the qualification. No, it's very helpful, and it's helpful to go back and revisit this stuff because it's not straightforward. But yes, one of the interesting issues that's arisen is for the interim arrangement, you must have an arbitral institution. But now you have a supplemental arrangement on enforcement. You can actually apply for interim measures post the arbitration in the mainland, even if you didn't have an arbitral institution, if it was ad hoc. So one wonders if there may be yet another arrangement put in place at some point that will clarify that issue. We will wait and see. Let me turn now, I suppose, to Jern Fay then. And Jern Fay, I imagine you've helped many clients out of dismal swamps, as Peter referred to earlier. But I want to stick with the theme that Peter raised here, the issue of jurisdiction in relation to the tribunal's authority or jurisdiction to determine the dispute. And in your experience, how have you seen this challenged? Peter gave a number of examples in his talk. What about yourself from the sort of arbitrator side, and also, of course, from your extensive experience as counsel?
Well, Ben, this is a very topical issue, and I just want to divide upfront my answer into three parts or three elements. The first is I'd like to talk about the most recent case law in respect of this very issue. In other words, whether or not the question as to the extent to which compliance with the pre-arbitration tiers of a tiered dispute resolution clause goes to the question of jurisdiction, or it goes to the question of admissibility. And perhaps in some sense, the answer to that question may necessarily resolve what Peter identifies as the perhaps all too common predicament of jurisdictional issues being accelerated so that they are decided prior to the underlying substantive issues themselves. And insofar as the case law is concerned, we have seen an evolution in the thinking, certainly on the part of common law judges and common law jurisdictions on the issue, because if you rewind back to maybe some 5 years ago, there was a growing body of case law, certainly in England and Singapore, which tilted in towards the view that strict compliance with pre-arbitration tiers, for example, settlement discussions or mediation, of a tiered dispute resolution clause goes to the heart of the question of the jurisdiction of the arbitral tribunal to determine the issues in dispute. So you saw, for example, the decision of Mr. Justice Tier in the English Commercial Court in a case called Emirates Trading, and there was also the decision of the Singapore Court of Appeal reversing the decision of the Singapore High Court in a case called International Research Corporation, PLC, and Lufthansa, where again, it was held that strict compliance with a tiered dispute resolution clause is essential and goes to the question of jurisdiction. However, of late, we have seen an evolution in judicial thinking of this, certainly at least insofar as the courts of England and the courts of Hong Kong are concerned. And in that regard, what's really kicked things off is a decision of the English Commercial Court in a case called Republic of Sierra Leone and SL Mining, in which the English Commercial Court held that the question of compliance with a tiered dispute resolution clause goes to the question of admissibility of those claims which it is alleged had not in fact been through the tiers of the tiered dispute resolution clause, rather than to a question of jurisdiction. And a similar outcome was then adopted by the Hong Kong Court of First Instance, the CFI, in a case called C and D, which was handed down earlier this year, in which again the court adopted the approach whereby it was held that compliance or not, as the case may be, with a tiered dispute resolution clause again goes to the question of admissibility rather than jurisdiction. Interestingly, and very recently, on the 8th of October of 2021, in other words, barely 3 weeks ago, the English court, yet again, English Commercial Court, in a decision by Mr. Justice Calver in a case called NWA and SSY versus NVF and others, held similarly that the question as to compliance with a term of an arbitration agreement that the parties should first seek to mediate a settlement of their dispute before referring the dispute to arbitration is a question that goes to admissibility rather than to jurisdiction. So it would seem that at least as far as the English courts and the Hong Kong courts are concerned, there has been an evolution in their thinking so as to classify such disputes as one going to admissibility rather than jurisdiction. I've got two footnotes here I want to set out. The first footnote is that as any good legal practitioner would tell you, obviously everything turns on a proper construction of the terms of the dispute resolution clause concerned, because it may well be that the way in which a particular tier dispute resolution clause is worded is cast so that and the prior tiers are regarded as necessary preconditions, conditions precedent to arbitration, and therefore would be one that goes to jurisdiction rather than to admissibility. That's footnote number 1. Footnote number 2 is that the position in Singapore, interestingly, at least as far as the current case law is concerned, stands in marked contrast to the changed or evolved position in England and Hong Kong, because the prevailing case law in Singapore remains that of the Singapore Court of Appeals decision in International Research Corporation and Lufthansa, namely that strict compliance with the pre-arbitration tiers of a dispute resolution clause would be required and is an issue that goes to jurisdiction rather than admissibility. So that's the first of my 3 topics or 3 segments. The second is that to date, Peter and I, at least up to this point, have been focused on the position as far as commercial arbitration is concerned. Can I just point out that the position is, and the considerations, therefore, which are to be brought to bear in respect of investment treaty arbitration could be, and indeed more often than not is different, because one can imagine, for instance, there could be a dispute as to whether or not the claimant is an investor within the meaning of the treaty giving rise to a claim, and that is the sort of issue that one would ordinarily expect without more to be decided perhaps as a jurisdictional issue on a bifurcated basis, or perhaps whether the question as to whether the investment that is made is a qualifying investment for the purposes again of the treaty claim that is being brought is again an issue that one would ordinarily expect perhaps to be decided as a prior to the determination of the underlying issues in the claim concerned. So that's sort of the second segment. The third segment, or third area which I'd like to touch on is, interestingly, is just to build on something that Peter touched on earlier on, where he adverted to the UK Supreme Court decision in Enka and Chubb, whereby it's a very long and terribly complicated judgment for all sorts of reasons. But in Enka and Chubb, in gist, is that where the parties have not designated, whether expressly or impliedly, the law that governs an arbitration agreement, then there are obviously certain considerations which are taken into account in determining the law that governs that arbitration agreement. And in the absence of an express or implied determination, then what the courts will do is they try to seek out the law with the closest connection with the arbitration concern, which the presumption being that all else remaining equal, it is the law governing the matrix or the underlying contract, as opposed to the seats of the arbitration. Now, interestingly, and this is just by way of a comparison or contrast, Article 90 of the draft revised PRC arbitration law is premised on a slightly different basis, which is that in the absence of an express determination of the law governing an arbitration agreement, then what the current draft actually provides, and I'm not obviously qualified to express an opinion on PRC arbitration law, but as what I hope is regarded as a diligent student of arbitration laws of different jurisdictions, I was interested to note that Article 90 of the draft revised PRC arbitration law provides that in the absence of express determination of the law applicable to an arbitration agreement, what the courts will then look to next is the seat of the arbitration itself. Now, this is interesting because this echoes the dissenting opinion of Lord Burrows in Enka and Chubb, which is a minority opinion. But interestingly, there have been a number of academic commentators which have since mushroomed following the publication of the decision in Enka and Chubb, supporting the dissenting minority opinion of Lord Burrows. And very interestingly, that opinion where primacy is given to the seat of the arbitration as that which has the closest connection, or at least the law of the seat being that which has the closest connection to the law applicable to the arbitration agreement, is a view which, on the basis of the present draft text of the revised PRC arbitration law, is the one that appears to be at least gaining favor for the moment, subject, of course, to consultation. So those are my sort of threefold observations on what is a very interesting and developing area of the law.
Thanks, Jianfei. That's fantastic. Thank you. Peter, I'm gonna come back to you. Looking back across the life cycle of the arbitration from your experiencing, and now focusing, we talked a little about jurisdictional challenges, but now going back to one of the key topics of the talk, which is enforcement. Are there recent trends that you can share with the audience in terms of what you've seen in terms of enforcement? And are there any specific concerns arising out of COVID or other procedural changes?
Thanks very much, Ben. Just before I move on to that enforcement, Jianfei, you mentioned the Emirates trading case, Tier J. Now, in the days when you could have 60 people packed tightly into one of your conference rooms in your office and hold seminars, we used to run seminars at HFW. And I remember when Emirates Trading came out, and yes, Tier J rather changed the dial when it came to clauses which, up until that stage, and Jianfei, you will correct me if I'm wrong, had been dismissed regularly by English judges and Hong Kong judges as simply being too woolly and unenforceable. Anyway, he changed the dial for everyone, and now we're grappling with it. But I remember, I think the clause in that case referred to the need for the parties to undertake, before arbitration is commenced, friendly negotiation. And I always wondered whether, if the parties stood up and said, well, actually, the negotiations were very unfriendly, it may have been the case that they had not complied with that clause. But anyway, let's move on to enforcement. So enforcement, where do you want me to start? We could talk all week about it. Primary focus is probably enforcement of Hong Kong awards in the mainland, given the topic today. Now, Jianfei has commented on the arrangement between Hong Kong and the mainland for the mutual enforcement of arbitration awards, and very informative, and I won't go back through that. As for recent trends, I think just given what we've spoken about today, what we've been looking at, probably worth, well, I thought I'd bring out and talk about two practical issues and concerns that I've seen when trying to enforce Hong Kong awards in mainland China. Now, I do want to stress at the outset that the situation generally is hugely improved from when I started practicing in Hong Kong in 1997. Now, on any basis, and those in practice for the last 10, 20, 30 years will almost certainly agree, that there are much fewer instances of questionable public policy reasons for the refusal to enforce otherwise legitimate awards. And also the pre-reporting requirements, which we haven't touched on today, but a lot of people will be aware of it, where the Supreme Court and then the Higher People's Court and then the Supreme Court, there's a time limit for the Intermediate Court to actually do something and make a decision. The pre-reporting requirements, such that it goes up to the Supreme People's Court level, has limited the risk of what used to happen, certainly before the arrangement in 2000. There was a risk that an intermediate court at the very local level would effectively sit on the award for years and years and do nothing because it was just too difficult a decision to make. So that has been taken out of the equation as well. So much better than it used to be. But from time to time, I've certainly encountered some odd decisions, and I'm going to talk about them today. Now, the first, which is relevant, relates to jurisdiction. So we were talking about, myself and Jianfei were talking about a challenge to the tribunal's jurisdiction. So what happens if that challenge is made? It's made before the Hong Kong tribunal. It's heard, it's properly dismissed by the Hong Kong tribunal. And there may have been witness evidence that led the Hong Kong tribunal to dismiss that jurisdiction. In the particular case I was involved in, there was, about the terms of the contract. And the tribunal, having issued its award on jurisdiction, the case then went ahead on the merits, and we had other witness evidence and expert evidence. And subsequently there was an award, and the award wasn't honoured, and steps were taken to enforce that award in the mainland. Now, as to this, I have one of the grounds in the New York Convention in mind, and it is has identical wording in the article. It's For those who are interested, it's Article 5C of the New York Convention, and it has identical wording at Article 7.3 of the arrangement between Hong Kong and mainland China. And the terms of that ground, whereby a court of a contracting state may refuse an application to enforce, the terms are where the award deals with a difference not contemplated by or not falling within the terms of the submission to arbitration, or it contains decisions on matters beyond the scope of the submission to arbitration. So you can see a little bit of a jurisdictional angle there. So I have regrettably seen that provision applied by the mainland courts in the context of the case that I was just describing as a reason not to enforce an HKIC award. And in that case, the tribunal had agreed to bifurcate. Jurisdiction had been determined by the tribunal after a fully contested hearing with witnesses. Then there'd been a full merits hearing. Then there was a failure to honour the award, enforcement in the mainland, but the Intermediate Court, the Higher People's Court, and then surprisingly, the Supreme People's Court all refused to enforce with decisions that can only be described as perverse. In effect, the courts all the way up allowed the reopening of the jurisdictional challenge on the basis of Article 7.3, as I referred to above. They allowed the reopening of that jurisdictional challenge that had been determined by the tribunal following witness evidence without hearing any evidence, and took a contrary position to the tribunal. And the decision was shoehorned into Article 7.3 of the arrangement. Second example, and this is a case which I have on the go at the moment. And it's relevant, bearing in mind it's Hong Kong Arbitration Week. We're in the HKIC lovely premises. I have a case currently at the SPC level, and we're waiting for a decision. But our client's mainland lawyers have been knocked back both at the Intermediate Court and the Higher People's Court level. Now, I've mentioned this before in other panels. Ben and I were on a ICC panel a while back, and I mentioned it then, and I've mentioned it since. That it's really something, and I'll explain why, that all arbitral institutions need to be aware of in the context of the increasing number of changes to institutional rules. And I'm sure there are events going on this week where people are waxing lyrical about the institutions bringing into play lots of different rules, more and more sophisticated, happens all the time. So I was acting, or we were acting, for a client in a high value claim, multi-party dispute, where the arbitration clauses across 8 or 9 different contracts were identical, all provided for arbitration in Hong Kong, administered under the HKIC administered arbitration rules. The facts were all interrelated, and hence before the HKIC, single arbitrations were commenced under multiple contracts. And for those interested, that's Article 29 of the HKIC rules. And those arbitrations were subsequently consolidated, and that's under Article 28 of the HKIC rules. Now, the disputes went ahead to a single consolidated determination of the merits, with factual witnesses, with expert evidence, and liability was decided or determined against 4 respondents, some, not all, but some on a joint and several basis. Now, the respondents were fully represented. They had an SC in Hong Kong and a junior. And although the HKIC rules, after the HKIC has determined whether to allow a single arbitration to be commenced against multiple parties, and or where the HKIC under its procedural rules has decided that it's appropriate to consolidate 2 arbitrations into 1, or 3 into 1, or whatever it may be, the rules expressly provide for the respondent to challenge that decision before the tribunal. So we have a respondent with an SC, fully lawyered up, took no challenge at all, merits hearing, and the respondents failed. So one respondent was based in Singapore, no real trouble with enforcement, and the client made a substantial recovery, albeit in part only. So we had the balance due and owing under the award against 3 respondents, all based in the mainland. And despite the arrangement, the Intermediate and the Higher People's Court, as I mentioned, have refused to enforce that award. Now, the grounds, as advised by our client's mainland lawyers, are that the judges at the Intermediate and Higher People's Court level are unfamiliar with single arbitrations commenced under multiple contracts and consolidation. Now, obviously, there's no merit to that at all, and we are hopeful that the SPC will make the right decision, and I would say confident. that the SPC will make the right decision, but it's awaited. But it does illustrate the wider point I mentioned, that the users of international arbitration around the world, for all of that and for all of them, and it's not cheap, we know that, there's little or no point in institutions introducing ever more sophisticated rules and procedures if those very same rules and procedures will simply cause problems in the local courts at the enforcement stage. So it's something I would submit quite strongly that the various institutions get a handle on before more and more rules are introduced. Are those rules going to effectively put awards at risk? Or is there some kind of dialogue that should be taking place with courts in various countries where those awards under the SIAC rules, the HKIC rules, the LIAC rules, whatever it may be, with those courts who are actually going to receive those awards, so that if there's any uncertainty, they can be dealt with. That's what I was going to say about trends, but I can comment about COVID if you want me to.
Yeah, go on. You've got 1 minute, Peter.
1 minute.
To cover COVID. It's not a complicated topic.
Well, it's actually, it's not, yeah, concerns about, specific concerns arising as a result of COVID and enforcement. Well, I don't know, I've read quite a lot about it. Someone suggested that, or one writer, I won't take the credit for it, that there could be a problem with remote hearings, that perhaps an unscrupulous respondent could say, even if they participate in the remote hearing, that when it comes to enforcement, the fact of the remote hearing resulted in them not having a proper and fair opportunity to deal with their opponent's case. There could be time zone issues, inconvenient. It was 1 o'clock in the morning for us. Our technology was rubbish compared to the technology everyone else was using. The translator for our main witness was very unclear because it was remote. Now, one option that I have seen raised, and I'm not taking the credit for it either, but one option is that to ask the tribunal when making an order for remote hearings, and this is going to go on, we know that, the tribunal should also direct that both parties, invariably the respondent, in effectively agreeing to remote hearings, because most respondents will agree to it at the time, they are also waiving any rights to raise an objection in due course, i.e. at the enforcement stage. It certainly won't do any harm, and it may help. Finally, on COVID, I was just going to say that it's not all bad news. Certainly in my experience in the last 12 to 18 months, and I mentioned LCIA, SIAC, HKIC, I see arbitrations moving a lot more quickly now. Tribunals are much more ready to hold interlocutory hearings. They say, right, we've got 2 or 3 things going on. We've got a CMC, we'll have a second CMC, we'll have this procedural hearing. Let's have an interlocutory hearing. So they're cutting through the sort of 6 or 7 rounds of written submissions that sort of was always the issue with arbitration, that frankly, there were some times when the parties were so diametrically imposed at an interlocutory stage, it would have helped if they could go before a judge and the judge just make a decision, and then everyone moves on. As I said, in my experience, COVID has seen arbitrators much more inclined to have a Zoom hearing or a team hearing and just get it dealt with in an hour or an hour and a half, as opposed to lots and lots of exchanges. So that's my comment.
Thanks, Peter. Yeah, so we've sort of gone all around the houses a bit here, haven't we? So we started off by talking about decisions that commercial parties make at the very start and when they're entering into their contract, and what their priorities are when they're putting together an arbitration agreement and a dispute resolution clause more widely. We've talked about some of the problems with that in terms of the dispute resolution clause. We talked about the multi-tiered clauses and how that can give rise to jurisdictional challenges, and of course the ever-present concern about enforcement, which is part of the reason that you enter into an arbitration clause in the first place. And we thought it was all going a bit swimmingly, and then Peter and Jernvey have told us how these problems sometimes give rise to unexpected results. So, it's all starting to sound rather complicated again. And I was just wondering if we can go back again to the beginning when people are putting together these dispute resolution clauses and turn to Sharla and say, are there other ways in which the parties might seek to mitigate the risk of, I'll say unsuccessful enforcement, but really the risk of all these issues arising For example, by trying to resolve the dispute amicably at an earlier stage. I mean, it seems rather basic, but what can we do, I suppose, to stop these issues arising later on and still reach a conclusion that everybody is comfortable with?
Thank you, Ben. That's a great question. And I guess it, from hearing Peter and Junfei's comments, I think we can see how it's a somewhat fraught question, and it's complex because on the one hand, you have these options for mediated settlement, but on the other, they can pose some complications if they don't succeed, and complications in terms of whether these preliminary steps were in fact followed, etc. But I guess, I will just add to the conversation some developments that I think are encouraging for those who are thinking about this option. We have, of course, the Singapore Convention. I'm sure many in the room are familiar with this, and on the panel.
Sorry, this option being mediation, Charlotte. So
right.
This is another, so just for those. So another option is let's get ourselves to mediate and make it part of the deal. Yeah.
Right. So pure mediation then is definitely something that is envisaged under the Singapore Convention. So a cross-border case. Could then have the option of enforcement, and that's what the aim of the Singapore Convention is essentially to provide parties with an option for enforcement of these mediated agreements or outcomes. And so the status at this time is that 53 states have signed this convention, and now 9 have ratified. I think 2 in the last week. I think Turkey and Honduras in the last week. So Singapore is a ratifier as well from our region. So it's a sprinkling of countries. It's not the New York Convention status in terms of numbers of signatories and ratifiers, but it's emerging. And I think what's happening now, as I understand, in mainland China, there's study of this convention and discussion about how, a number of provisions and laws and domestic regulations need to be put in place for this to be implemented. So, for example, how distinguishing pecuniary awards from other forms of award based, for example, non-pecuniary awards, how those will be distinguished and who will oversee the implementation. All of this is being worked out. So it's complex, but it's not to say it's not in process. What I will say is there are a few arrangements where mediation has been envisaged and has been approved as a sort of mechanism for final enforcement, and that's CEPA, so our closer economic partnership arrangement between Hong Kong and mainland. This is more on the investment side, but it's instructive, I think, in terms of the direction that we're seeing in terms of what's being encouraged as a mechanism for resolution. So CEPA does include mutual provisions both from mainland side and Hong Kong side to seek resolution. There are about 5 or 6 options on each side for resolution. They're not tiered in the sense that we understand, but they are options that are mutually exclusive. So one could seek out amicable consultation or, of course, arbitration or mediation as separate, distinct options. For mediation, if it's in Hong Kong, it would have to be through an institution, and vice versa in mainland. So this is under CEPA. Then we also see some new bits, BIT, bilateral investment treaty arrangements between Hong Kong, for example, and the UAE. There was one that was recently signed in 2019. And this also provides for conciliation as a precondition. So here it's a tier. This can be enforced on the side of states. States can require investors to undergo some form of conciliation proceeding, but not vice versa. Investors can't force this upon the state. So this is interesting, and I think they're instructive, though these are in the investment side, and I think we're focusing here more on the commercial side. But yes, it's all somewhat in formation stage at this point.
Thanks, Charlotte. That's really helpful. And so, what we're looking at there are other ways to resolve our dispute and still end up in a situation where we can enforce the ultimate conclusion, mediation agreements. That's a really exciting development with the Singapore Convention, and you mentioned CEPA as well, trying to achieve a similar outcome. But go back to the commercial people who are making the decision at the start when they're putting these agreements, and I'll turn to you, Yun, here. How is mediation perceived by the business people as a tool for dispute resolution? So if you go back there at your midnight negotiation session, what are the sort of issues that are raised when you start talking about mediation at that stage?
I guess for the construction industry, mediation is very, very common, and it's like almost, it's compulsory almost, because as mentioned earlier, we are using a lot of the standard form contract in the construction industry. So, and then those standard forms all contain a mediation clause as a conditions precedent to arbitration. So this means that you must mediate first before you can commence arbitration proceedings. That said, I guess the community here in Hong Kong has a growing cynicism towards the effectiveness of mediation, and that possibly there are a few different factors that contribute to that. Number one, possibly it's because it's compulsory, it's mandatory, so which is inherently basically contradictory to that the process of mediation, which means active participation. If you make it compulsory and people don't really want it, then there's no active participation, which doesn't give you a good result. The second issue that pops up in mediation is basically it's generally done in early stage, in a stage where parties have not necessarily already articulated their claims fully. So it's very, very hard to narrow down issues or to resolve a dispute if you actually don't have a full picture of what the claims are. And then I think there's a third problem to mediation, which is that most of the time people see mediation as something that's short and effective and fast. And mediation clauses will provide, for instance, for a 60 days or 90 days resolution period. But instead, like we have experiences that it takes over a year. Because the other side will expect you to particularize or to justify your claims up to arbitration standard, which defeats the entire purpose of mediation. And yeah, it's a lot of waste of time and resources. We at Gammon, we're trying to take mediation very, very seriously. We do basically ask our senior people to attend to mediation so they will be in a position to resolve the disputes. We also take very serious, we basically consider the claims, the claims very seriously, and trying to not waste time and effort and mediate in its proper sense, basically.
Thanks, Ian. That's great. So we've had a real, as I say, a bit of a roller coaster ride here. We started off looking at arbitration clauses and how they're putting in the last minute, and active and passive participation, which Karen was talking about. We looked at the problems that arise, you know, as we go along that can be mitigated by this interim measures arrangement, for example, and problems that perhaps aren't possible to foresee, like jurisdictional challenges along the way. Enforcement, of course, has been a hot topic. And then we looked as well at this possibility of sort of leaving it all to one side for a bit and trying to make mediation compulsory and something that everyone thinks about, rather to overcome the possible risk of enforcement later on. And Yun was saying how some business leaders, however, are a little bit hesitant, should we say, about the sort of inclusion of mandatory mediation. And I guess that may also give rise to some of the problems that Jernfei and Peter talked about earlier, about multi-tiered dispute resolution clauses. So there's a connection there. So we've got about 5 minutes or so left. If anybody has any questions from the floor. Yes, madam. If you could speak into your microphone, that would be great, because some of the guys online haven't.
Sure, thank you. I actually have a question for the case just shared by Mr. Murphy about the SPC case. I'm wondering if there is any other grounds for the High Court or Intermediate Court to refuse the enforcement of the awards, because first of all, actually not familiar with arbitration practice such as single arbitration under multiple contracts. It's not a ground to refuse to enforce the award under the current Jersey law. And secondly, actually, it is not new practice in the mainland, because for mainland arbitration institutions such as CPAC, they also have arbitration rules regarding single arbitration under multiple contracts or consolidation of arbitrations. So I'm just curious if you're allowed to share more about the grounds, the real grounds for the Intermediate or High Court to refuse enforcement of the award.
Thank you very much. Well, so far as we understand, those are the real grounds. The problem is, as you know, if you know that the procedure when you're enforcing in the mainland, you don't actually get to see the decision until it works its way up to the Supreme People's Court and then it comes back down. So at the moment, we don't have the written decision. All that we have, as I mentioned, is what our clients, PRC lawyers, understand to be the position from discussions with the Intermediate Court and the Higher People's Court, because at the moment there has been no decision that's been published. The decision will come down after the Supreme People's Court have either disagreed with the Intermediate Court and the Higher People's Court, or agree with them, and we're hoping that they will disagree with them. But the PRC lawyers, the advice we have, or our clients have received, is that it does seem to be that in an arbitration, and fully appreciate, under CTAC, there are provisions for consolidation. I'm aware of that. The information that we've received is that there seems to be uncertainty and an absence of familiarity, if I can put it like that, of a case where there was both the commencement of a single arbitration against multiple parties and the subsequent consolidation. And that seems to be the issue. But we won't really know until it comes back down from the Supreme People's Court. And at that stage, my understanding is it's publicly available, so everyone else will hope someone might do a report on it. But that's what we understand at the moment. But as I said, we don't actually have the written reasons.
Thanks very much. Well, if there isn't any other pressing questions, and we'll be hanging around, so those of you who are here in person can obviously approach us, though fortunately for Jern, Fei and Sharla, you get green cards for this bit. Can I just say a huge thank you again to everybody here and everybody attending at home and from the office for attending. We really do appreciate it. It's been great to see you all. We usually would give gifts at this point to the panel members, but what we've done this year, if you know, hopefully nobody minds too much, is that we are HFW supports a number of charities, one of which is called the Nesbitt Centre. The Nesbitt Centre is an institution for empowering adults with learning disabilities through vocational and social enterprises. And the Nesbitt Centre has actually catered our event today. So those of you who've enjoyed the coffee and tea and cookies and biscuits and things like that, that all came from the Nesbitt Centre. So thanks to them. And we're going to give a gift, a donation to the Nesbitt Centre in lieu of gifts this year, if that's okay with you all panelists. So many thanks on their behalf. And also, of course, on our behalf for your efforts today. We really do appreciate it. Those of you who are here, I understand we do still have some coffee and tea and cookies and things over on the corner, so we can continue these discussions afterwards. And for Jern, Fei and Sharla, thank you so much for coming. And for everyone online, we really do appreciate it. And we look forward to seeing you next year. Enjoy the rest of Hong Kong Arbitration Week, which promises to be better than ever this year. Thank you very much.
Thank you so much.
Thank you.